Okay, Joaquin, we got it.
Thank you, Gretchen, and good evening, everybody. It is 6:01 on August the 4th, and I bring this meeting of the Disability Rights Task Force of the Human Rights Commission to order. And here at 55 Court Street, we have a gavel. Dare I use it? Dare I use it? All right. What we'll do, welcome and introductions for those of us here at the dais and online. And let's start in person. Robert, do you want to get us started tonight?
Would love to. Good evening, everybody. My name is Robert Marshall. I use he, him pronouns. I live in Ward 2. I am the vice chair of the Human Rights Commission and a member of this task force. I will pass it to my right to Christina.
Christina Ballard, she, her pronouns. I'm a commissioner on the Human Rights Commission, and I'm a member of this task force.
Gretchen, you want to round us off in person here?
You bet. You bet. My name is Gretchen Bennett. I'm the staff liaison to the commission and use she, her pronouns.
Haley, do you want to get us started online?
Sure. My name is Haley Barenbaum, Ward 7, finally figured it out. And I'm a member of this task force. Oh, and I use she, her pronouns.
Thank you. Tony, do you want to get us started or go next?
Sure. I'm Tony Marys. I use she, her pronouns. Like I said on the map, I'm not really in a ward because I'm north of the Parkway. But I do live in Salem Housing Authority subsidized housing, and I'm a member of this task force. Thank you.
Thank you, Tony. John, do you want to round us out?
Hi, I'm John Doris. I'm a guest speaker for today. I'm with the Northwest ADA Center. I'm assistant director there. I live in Seattle, and I use he, him pronouns.
Thank you, John. And I will say, both, I think you were told prior to the start of this meeting, but for those of us here, our parks person has fallen ill and will not be joining us tonight. So item 4A will be scratched from the agenda. We do have public commenter today. If you wouldn't mind coming forward and speaking to the mic. When it's green, it's lit and we can hear you. And if not, we can't. Thank you.
Do we give our address?
Just introduce yourself and your ward if,
Sure.
Yeah, thank you.
7. I am on the Dome Building Community Coalition Task Force. We are creating a nonprofit, so I don't have an official title yet. I wanted to come to you today to talk to you about the project we are taking on here in Salem, and everyone online, hello. Project we're taking on here in Salem, and it's to work on the DAS to be granted the Dome Building, which is on North Campus of the State Hospital. I assume most of us are familiar with that building. It is a very old building here in Salem, and it's been empty for the past while. Our goal is to create a coalition of community partners, members of government, citizens, people who are parts of other nonprofits and other nonprofits in the area in order to turn the Dome Building into a community center, community hub, a youth coordinating area. There's a million things we can do with it. Space for nonprofits to inhabit and so much more. Because this building has gone through a history of, we all know the history. It was the entrance to the state hospital for about 70 years, and then it was part of the Department of Corrections for about 30 years. And we want to bring to it some life with the North Campus being revitalized and housing being put in there. It's the population of that area specifically is growing immensely, and the services, especially for Yaquina Hall, which is right next door, for unhoused citizens. There's just no services. I think the closest one is probably Safeway, which is about 1.25 miles down the street. So we would bring in services to that, low cost thrift stores, sundry stores, maybe a bookstore of some sort, but services for the community, specifically in that area. But again, larger spaces for nonprofits to hold events, for housing at some point down the road. Hopefully our big goal is to house unhoused youth, because the historic property actually had what they called an orphanage many years ago in the 60s, was torn down. So a historic reuse of the building and the property would actually be to house unhoused youth, which I think would be great. I am the treasurer of a nonprofit called Leaders that works with unhoused and BIPOC populations. And so that's sort of a goal of our nonprofit specifically. I wanted to introduce myself, and you think, well, what does this have to do with us, the commission? It's because I believe that everyone in Salem and everyone in the community should have a part in this. This isn't gonna be just a me thing, just an us thing. This is something that all of us can partake in. And hopefully someday, maybe you guys can even have a meeting in one of our conference rooms. But that's why I'm here. I can take any questions you have, or I can answer any questions you have. Other than that, I have given you a sheet, and I believe it'll be sent virtually. And you can go to domebuilding.org to get some more information. And we'd be happy. So this is the request. If you want to sign on as a supporter, we'd be happy to add you to the list. Staff, members, chair, everyone who's interested. Yes, speakers from Seattle.
I do have a couple questions. So last time we talked, you hadn't incorporated the 501c3 yet. Have you done? Is that
We just got the EIN and we're incorporating actually tonight.
okay? Great. And could you give us a little bit of the history on? The other day you told me a little bit about it, about people who've come forward in the past who wanted to revitalize the dome building, and then it backs off, and that history.
The building, this is a funny story. The building has an interesting history of, they just wanted to get rid of this for a while. It's costing all of us money every month. There are about 6,000 small 4x reasons why we should, support this. And they're the small little pieces of glass that are constantly being broken. There's 6,000. And each one costs $20 to repair, and so that times 6,000. It's just small things, historic preservation wise, like that a big corporation or someone or whatever couldn't put that historic preservation into. It's the little things in the building that needs to be tended to. And so over the years, there's been RFPs. There's been they tried to sell it on the market twice. No one wants it because why? Because it takes a lot to maintain a building of its historic nature like this. And so a nonprofit can tap into sources, both private, federal, and other historic, that can do that preservation on site without having to cost the taxpayers any money upfront or in any way. So it's gone through a process of people getting really interested in it. Someone says, oh, we're gonna do this. And then we go down that road for a little while and it fails, and then everyone forgets about it for a few years. And oh, it's really interested, and it goes down that road and everyone forgets about it and it fails again. This has been a cycle for the past 30 years, up and down and up and down. And we want to end that cycle now because the building itself is not going to survive another cycle. It is being maintained, like I said, by the state at our cost. We want to take that on. We want to take on responsibility of protecting and preserving. But we have to end the cycle. We cannot go through another process of people really interested. That's kind of happens in Salem a lot. You get really interested in this thing, it plateaus, it falls off, people forget about it. It comes up, go down. So that cycle needs to end, and I think we, the commission, or the coalition, you're the commission, I'm the coalition. The coalition is the group that can end that cycle and bring the building to public use as opposed to just sitting there and rotting until, oh gosh, like Howard Hall on, if you remember Howard Hall on the blind school, gosh, it just has been decayed to the point where we have to tear it down. That's just a shame, isn't it? Well, yeah, because you let it decay that long. That's what happened. So I don't want to see that happen to this building. And that's one of the driving factors for me personally in this project. And that's a long explanation.
Well, no, that's what I was asking for, but so the interest from the Disability Rights Task Force is that you would plan on having some services there, some sort of social services that would do outreach or support people with disabilities.
Absolutely. There's a multitude of space in the building itself. You could have offices there. We could have community hubs where people could get those resources. We could have drop-ins where people could talk to counselors. There's a million things we could do with the space because there's so much of it. Several programs have expressed interest in putting, some stuff there, and I can't talk about all of it yet because it's sort of still in the works. But yes, it would be somewhere that the community could have a hub of access to programs that you guys can come up with and we can add to the list of supporters and.
Thank you.
Thank you. Thank you for your comment today. A couple questions. How large is the building?
It is 75,000 square feet. That's 20,000 in the basement, 20 on 2 levels, and then a rotunda of about 5,000 square feet.
Okay. And in what condition is the building now?
The outside is in good condition. Again, the 6,000 little panes of glass are constantly being broken. They're single panes. I know this is random and weird, but it costs the state a lot of money to fix those. And every time one breaks, instead of replacing it, we put up a board. Okay, you put up another board. And how long is it until you have boards all over and it looks like an abandoned? So the inside had been, I kind of equated to a college dorm. Kind of that. It's there's no central air, there's central heating, but it is kind of old industrial carpet. It was inhabited right during the beginning of the pandemic, and then the Department of Corrections left. So essentially, it's the 75,000 square feet minus the basement, which is empty. All the space is subdivided into tiny little rooms, right? And so when we go in there, the idea would be to clear out some of those rooms and make space for other things. So it's not like permanent walls on the inside. It's very segmented into little spaces, but it's in okay condition on the inside.
Thank you. I think you've approached the commission in a good way here because this is a Disability Rights Task Force. I think any public endorsement, for lack of a better term, would have to come from the full commission, which we are not in a position to do, representing only a portion of it, of the larger commission tonight. I see here that you have Kimberly Fitzgerald as a potential coalition partner.
She is very excited.
Yeah, and so she I'm sure has already introduced you to the Historic Landmarks Commission.
I was the historic for 8 years.
Okay, great.
Planning Commission for 8 years too. So
All right.
I'm very familiar with Kimberly. Yes.
Okay, great. So I think, something as chair of this commission, I would like to see that go through a Historic Landmarks Commission process and a Planning Commission process if there's any intended use changes or any zoning changes that are required. I will say I'm on the Planning Commission, and so I'm a little wary as to how much I can speak because that might amount to an ex parte communication, and I can't do that. And as a former commissioner, you I'm sure are familiar with those rules. But I do appreciate it, and I think it certainly is of interest to us, and I look forward to bringing it to the full commission and maybe having you back to the full commission for a presentation.
Like I said, and I am going to Planning Commission just to do a public comment and Historic Landmarks. I noticed your meeting this month was canceled, but I will be at council every week.
The 5th was canceled, but the 19th was not. So. Great. Well, thank you so much. And please reach out to Gretchen to get my information if you want to be in touch. So thank you.
Thank you.
All righty. Are there any member remarks or announcements on non-agenda items tonight? Hearing none. John, I want to welcome you and thank you for sharing your time with us tonight. We've been on this, we're a temporary body. I'm sure Gretchen's already given you the lowdown, but we're a temporary body as part of the Human Rights Commission that is exploring challenges, kind of frontier issues around accessibility for our disabled community here locally in Salem. I know you're located in Seattle, but you're in part of this larger Pacific Northwest community, and so we welcome you all the same. And we're hearing from leaders in this space, planners, parks people, as well as service providers. And then this month and into next, going out into the community and hearing directly from folks themselves. And so your time is appreciated and a part of that process as we kind of make our way through the year and head into the fall and winter with recommendations to our city council here in Salem. So thank you, and looking forward to learning more about your work and what overlap there may be with ours and what we can learn from it.
Awesome. Thank you very much. Thank you again for having me. I will start the PowerPoint. Can everybody see that okay? Okay, awesome. So today I'm going to talk a little bit about who we are, the Northwest ADA Center, and then some of the topics that we have that a lot of people have questions about related to the ADA. So again, my name is John Doris. I am an attorney. I am admitted in Florida. I moved to Seattle almost 2 years ago, and I've been with the Northwest ADA Center for almost 2 years. And my current position is assistant director. So what is the Northwest ADA Center? Well, it's part of the national network. On the screen is a picture of the United States in the 10 different regions. And the Northwest ADA Center is Region 10, which includes Alaska, Idaho, Washington, and Oregon. So all of the ADA centers have the same core function of providing information about the ADA to the community and promote voluntary compliance. So when the ADA was passed, we just celebrated 35 years. These centers were created as well to help. Originally, the idea was businesses will be concerned about how expensive it is. So the centers were created to give them some guidance about their obligations. And over time, they've expanded to really focus on anyone that has a question. So we get questions from Title II entities, Title III, the whole community, really. So all of them have the same core mission of providing information about the ADA. The number on the screen, 800-949-4232, is the national hotline, and it will route your phone calls based on your number. So I'm originally from Florida. If I called with my 407 number to the hotline, it would be routed to the Southeast region. The email address on the screen, nwadaCTR@uw.edu, will bring questions directly to us at Region 10. We are housed at the University of Washington. It administers our grant. So legal advice disclaimer, we include this at all of our presentations. We're providing information about the ADA, but we're not providing legal advice or guidance. That's up to, we can point people in that direction, but it's always important for people to consult with an attorney in their state or in their community for the definitive answer to anything that's particular to their question. So again, our agenda, we'll talk about the Northwest ADA Center services, then we'll do a very basic overview of the ADA, and then we'll talk about Titles 2 and 3 and some of the bigger issues that come up the most often, which include reasonable modifications to policies, procedures, effective communication, and then service animals. And then if there's any questions at the end, we'll have time for that. So some basic services. What do we do? Our core mission is to provide confidential technical assistance. We provide confidential guidance, information about the Americans with Disabilities Act. That's our core mission. So we're essentially a neutral third party where people can call and sort of give us an insight into what's happening or what their question is about, and then point them in a certain direction to help them understand, well, generally, this is what the ADA requires or suggests is important or is necessary. And then they can go forward with that, whether we give them a referral to an advocacy organization or a bar association. Our goal is to help them understand the ADA. So we answer calls, email messages from everybody, public, businesses, government officials. We get questions from local libraries asking about, are there different apps that you're aware of to help with communication, or an agency may be having a temporary event, so they're concerned about accessibility. Do we have any advice to help with that? Or just people, and especially today in today's economy with people concerned about their jobs, we get a lot of Title I questions about workplace accommodations. So all of that is confidential. We do keep some information just for grant reporting requirements. And we do a lot of trainings. We do in-person and virtual, ranging from 60 to 120 minutes. We can customize the training depending on the needs of the organization. It's based on a sliding scale where many of our trainings had no cost. Sometimes if the training is very specialized, there could be a cost just for prep, creating that training because of the time and research, or if there's travel requirements. Very recently, I was in Oregon, and so there was some cost for that training just for the travel requirements. Some sample of ADA courses, some of our core training, all of the initial titles 1, 2, and 3, do general overview trainings. We do a lot of ADA and correctional institutions trainings to help them so corrections institutions, county facilities, they're Title II, but then they also have additional considerations. So that's a specialized training that we do, and I'm in Oregon a lot, actually, doing correctional institution trainings. Some recent customized trainings, accessibility in AmeriCorps, and then the ADA and disability justice. That was a recent specialized training for a historical society. Some services that we don't provide, and this creates a lot of confusion for people: enforcement. The ADA, all of the ADA centers avoid enforcement. It's just not part of our mission. It's not part of our grant. And that would sort of get in the way of being a confidential source of information if there was concern that we would be enforcing the ADA. So we don't have enforcement authority. If somebody is very concerned and wants to pursue an enforcement action, we can point people in that direction. But again, we retain just a little bit of information. Sometimes people will give us a fake name. And so we need a name and a state. That's essentially the minimum information that we record, just for our grant reporting requirements. In legal advice, we can't provide legal advice, and people sometimes will call us and ask us, and they'll say, well, this happened to me. Is that legal? Or can you write a brief for me? Or can you represent us in court? All of those things we can't. It's not part of our mission. It's not something that we do. There are attorneys employed at the various ADA centers. Again, I'm an attorney, but I'm admitted in Florida, so I couldn't give somebody legal advice in Washington or Oregon. But the core mission is not to give legal advice, but to give information. And many people will call asking for grants or assistance. The ADA centers don't provide grants or loans, but we can point people in that direction. If there's resources available in the state, or if there's nonprofits that have resources, we can help them or point them in a certain direction. So very basic. The 5 ADA titles: employment, Title I, apply to 15 or more employees, enforced by the EEOC. Title II, public entities. This deals with state and local governments, enforced by the DOJ. Title III is public accommodations, nonprofits, businesses, enforced by the DOJ. Telecommunications, enforced by the FCC's Title IV. And then Title V is miscellaneous, things that are important. They don't fit necessarily in the other titles, but they're all housed in Title V. So when you look at this list, think of it as an attempt at ensuring people with disabilities can have meaningful access to life, to be a meaningful participant. So many of us, we need employment, right? So there's employment protections. Public entities, if we may need a license, we may need to get help with a state or local agency to access programs that they're providing. Many of us may want to go out for coffee or go to the grocery store. That's Title III. And then we use the phones, telecommunications, Title IV. So all of these are meant to work together to ensure that people are integrated into society and have a meaningful participation. And I'll say this real quick, sometimes, especially because politics are different now, the current administration is definitely different than the previous administration, but I'll just point out that every administration has different priorities, and it doesn't take away your ADA rights. If there's an issue and somebody believes that they have a legitimate complaint that they want to file with the EEOC, they should do that. Or the DOJ, they should still do that. The DOJ, the EEOC, all of them have an obligation to enforce civil rights, not just the ADA, but all of our civil rights protections. So the purpose of the ADA, again, is a civil rights. People sometimes call us thinking, well, they'll ask, well, where do I sign up for the ADA, or how do I sign up for protections? You don't sign up for civil rights protections. Those exist whether you are aware of them or whether you know specific information about them. They're meant to protect you. So the ADA assures the same rights opportunities as everyone else, equal opportunity. And anytime I talk to a group about the ADA, I tell them, I know there's a lot of information, but if you walk away with this, only remember in a couple of words, make sure one of those is opportunity, because the ADA is really at the core is providing opportunity for people to participate in life, to meaningfully participate. So who is protected under the ADA, or definition of disability? Person with a physical or mental impairment that substantially limits one or more major life activities. So the ADA does identify some disabilities, but it's written in a way that's very broad, and especially with the 2008 amendments, it indicated that the definition of disability is supposed to be broad so that more people rather than less are included in its protections. Has a record of such an impairment, meaning somebody that may have episodic or have a disability that has episodic manifestations, or it could be maybe it goes into remission and it could change. So once somebody is identified as or considered as having a disability, they don't have to then prove it again, for example, or is regarded as having such an impairment, even if they do not, in fact. And this happens sometimes, especially in a Title I situation, where somebody makes a perception that an individual has a disability, and they may make a judgment based on that, when in reality, they do not have a disability. Also covered under the ADA, people who are discriminated against due to their association with the person with a disability. And this oftentimes is because of with family members, maybe a partner or a child. So we often ask people to think about the models of disability, think about how you think about disability. Traditionally, the perspective about disability would fall under the medical model, where we would view disability as having some kind of physical or mental limitation, and that deficiency was something that had to be fixed. And that's a very traditional perspective about disability. And that's not to say, I should say, discussing both of these, I'm not trying to suggest one is better than the other or one is more important. I'm just indicating that these are two different perspectives, and really they complement each other oftentimes. But it's important to understand that historically, when public policymakers are addressing disability, or when people are thinking about how to respond to disability, their viewpoint is often based in the medical model, that there's something that needs to be fixed or cured with healthcare professionals. The social model is asking you to put that perspective outside of the person, look at the community, look at the world around us, look at the built environment. And oftentimes it's these limitations that are disabling, functional limitations, impairments, and the physical and social barriers. So the example I like to use here is when I was growing up, oftentimes a doorknob would be a ball. And so you would open and close the door to have access by having to navigate with this ball. But oftentimes people with dexterity or many disabilities, you're not able to open or really navigate that ball. So why not have something else like a lever, a handle? So it's recognizing that the built environment itself around us can create can impose limitations on individuals. So it's helpful to just think about how you think about, or how all of us think about, people with disabilities, because it impacts the decisions that we make in terms of making adjustments. So Title II, this is state and local governments, counties, cities, transportation agencies, all of these enforced by the Department of Justice. So anything that a state or local government does, any kind of program, service, these are covered under Title II of the ADA. So Title II entities have a responsibility to make sure that their programs are accessible, that they make reasonable modifications so that people can access those programs and services, and they engage in effective communication. And we'll define those a little bit more. So those are really the core aspects of Title II responsibilities. They're prohibited from discriminating on the basis of disability, So they must make reasonable modifications to their policies, practices, and procedures. So when we think about Title I and making changes, that's dealing with accommodations to the workplace. When you talk about Title II, we're now using the language of reasonable modifications, because we all have policies and procedures, right? And sometimes those policies and procedures need to be adapted. And that's what the ADA is asking. Recognize that sometimes we need to make some modifications so that people with disabilities can access the programs, access the services, and participate. Title II entities need to recognize architectural barriers. Oftentimes there are physical barriers preventing access, whether it's to the facility itself or whether it's to online to access a program. Whatever those barriers are, especially the architectural barriers, need to address them. And then communicating effectively. People communicate differently. People with hearing, vision, speech disabilities can communicate differently. And it requires brainstorming oftentimes to make sure, well, what is the context? What is the substance of the communication? And then who is the target of that communication? Title II entities are not required to make unreasonable modifications, which means things that would fundamentally alter the purpose or nature of the program or the service or activity, or something that's an undue financial or administrative burden, or something that's a direct threat to health or safety. So these are kind of high burdens, especially financial resources, because when you're looking at the financial burden, it's not just the one entity, it's the resources of the larger body. So the expectation is that there's going to be resources to make those modifications. For Title III, these are public accommodations. These are the businesses in the community. The ADA mandates an equal opportunity to participate and benefit from the goods and services that the public accommodation provides, whether it's a coffee shop, bookstore, whatever it is that's a private business. Individuals with disabilities must be integrated to the maximum extent appropriate. So if they have a program, they might want to, depending on what the program is, like let's say it's a sailing program, they might create an adaptive sailing program in combination with both so that they're like parallel tracks. But the individual still has the opportunity to participate in the other program, the original program. You couldn't force somebody to be in the adaptive program. So Title III entities have what's called the standard of readily achievable. So this is looking at the architectural barriers for businesses, and their responsibility is to do what is readily achievable to address those architectural barriers. This is something that can be carried out without much difficulty or expense. So that's not as high a standard as a Title II entity would have to put more resources into addressing those barriers. So what does that really mean? If it's not readily achievable, they still need to take steps to make sure their programs, their offerings are available to the public. But readily achievable architectural and communication barriers, so whether this could be installing a ramp or making sure that there is a path of access within the building, addressing communication barriers. In this context, this means it could be signage. It could mean communicative information in the elevator. All of those things need to be addressed under the readily achievable standard. So if the removal is not readily achievable, still take alternative steps. An example, there's we get here in the Pacific, well, really across the country, but we'll get phone calls sometimes, and I'm aware of one particular restaurant in Washington where the restaurant is in this very old structure, and it was not readily achievable to provide access into the building. So what did the restaurant do? Well, they talked to the restaurant that was next door, and they made an arrangement. Well, if this restaurant next door did have facility access, it was easier to get in. So the restaurant made an arrangement so that people who were not able to get into the restaurant that was in the older building could still order food that would be delivered to the restaurant next door. So they were still able to access the services of that restaurant in an alternative way. So that's what this is about, is finding alternatives so people can access your services. Title III specifically requires public accommodations avoid any eligibility criteria to screen out people with disabilities unless there's a legitimate safety reason, and that would be a legitimate imminent direct threat. And that's a little bit hard to meet that standard. Unnecessary inquiries into disability, it's there's very little need to ask somebody about their disability, and oftentimes it's prohibited. And then any surcharges associated with compliance, the Title III entities wouldn't pass along the cost of that. And this oftentimes comes up in effective communication scenarios where a business may need to hire an ASL interpreter, and they may think, well, this is expensive. Can I pass along that cost? Generally, under the ADA, no. There are situations where it may be a financial burden, but that's a different conversation. So generally not passing along that cost. Title III, again, reasonable modifications. If you cannot reasonably modify the policy, then find an alternative. If it would fundamentally alter the nature of the goods, service, or facilities, then that they don't need to implement that change, or if it would create a genuine, legitimate safety risk. So what would be a fundamental alteration? Recently was doing a presentation with a group of mediators. And in mediation, this is a confidential process. So a modification, so somebody might request, because of their disability, to record the mediation. Well, that would be helpful for them, but that would fundamentally alter the nature of the mediation, because this is supposed to be a candid conversation between the parties where there's where you're protecting confidentiality, where that information is not going to be repeated. So an alternative would then be a qualified note taker. So instead of recording, you have a qualified note taker who can take notes for you, so that you still have the information. So fundamental alteration, you would still find some other alternative that you would still accommodate or still make a modification so that the person can meaningfully participate. What about personal services? A public accommodation should offer minor assistance, but the ADA does not require businesses to provide personal services. But the reality is they should offer some minor assistance if it's possible. An example here, a bank teller helping a blind customer. Oftentimes this would be, you see this in grocery stores, for example. Somebody may need some assistance and they ask a manager for some help. The manager could say, sure, and if it's really super busy, they might say, well, could you just wait, please, 5 to 10 minutes, and then I can help you. That would be a reasonable modification of their policy, because normally manager wouldn't be helping people grocery shop. But to help somebody with a disability, that would be reasonable. Effective communication. Public entities and businesses must ensure communication is as effective as that provided to people without disabilities. So it must be provided in a manner that enables them to participate and benefit. Again, meaningful participation. Public entities like Title II entities must give primary consideration to the preference of the person with a disability. A business does not have to give primary consideration, but they still need to provide effective communication. It must be effective. If there's an undue burden, then they still must provide the next best means. So factors to consider: what's the duration and complexity of the communication, the context, number of people involved, and/or the need for the communication, and the importance and potential impact. So if somebody simply needs to know directions, well, where's the restroom? That's a different kind of communication versus I'm going to sign a contract to buy an automobile, or in a dissolution case, this is the settlement agreement to divide all of your assets. Those are very different conversations. Auxiliary aids and services. On the screen is a picture. On the left side is what's called hand talk. This was Plains Indian Sign Language and a precursor of the ASL. The hand talk language was almost lost to history, but there's a push to save it, preserve it. So it's an example of an auxiliary aid and service. Auxiliary aids and services help to ensure equal access by offering alternatives to ensure effective communication. So there's many different types of of auxiliary aids and services. We oftentimes think of sign language interpreters, but there's different types of auxiliary aids depending on the disability. For hearing disabilities, you could use qualified interpreters. You could use written materials, different assistive listening devices, technology, closed captioning, transcription services, note takers, and video remote interpreting. Somebody with visual disabilities, you could utilize Braille or audio descriptions and recordings, large print, CDs, tapes. All of these have different price points, and all of them could be different or have different levels of effectiveness depending on the person, what's their preference, and the context. And so to wrap it up, let's talk about service animals a little bit, because there's almost always questions about service animals. We get a lot of questions on the hotline. So what is a service animal under the ADA? Under Title 2 and 3, a service animal is for an individual with a disability, often called a handler. And the service animal is individually trained to do work or perform tasks which is directly related to the disability. So guiding a person who is blind, alerting a person who is deaf, or picking up items for a person who uses a wheelchair. All of these things, the task that they're trained to do is directly related to their disability. It's a working animal, not a pet. Dogs and miniature horses can be service animals under the ADA. Local communities, cities, counties are free to change their laws to accommodate or to include different animals. King County here in Seattle has a lot more animals that are considered service animals. So remember, the ADA is a floor, like as in many civil rights laws. The federal law is the minimum protection. So for under the ADA, dogs and miniature horses are service animals. Under Oregon state law, service animals in training are protected as well. If somebody has issues or runs into some problems and they want to discuss those, they can always contact BOLI. They handle civil rights complaints in Oregon. So how do I know it's a service animal? There are 2 questions permitted when a person with an animal enters a space. So is this animal required because of a disability? And what work or task has the animal been trained to perform? So that's it, those 2 questions. Generally, it comes up with businesses, but sometimes Title II entities may run into these issues. It's possible. So those 2 questions. There's no registry or certification requirements or special attire. We get calls on the hotline and people say, well, where do I register? Or I paid $100 to somebody to register my animal and I can't find it. There isn't. It's the ADA does not require registry or certification. And then you cannot ask to demonstrate tasks or ask for information about a disability. Remember, sometimes a task may be not necessary at the moment. Some service animals perform tasks to warn of an upcoming event. And if that event isn't happening, like a seizure or somebody may be about to faint from POTS, then there's no task for them to do. So you can't ask them to demonstrate that. Where can service animals go? With the handler, a service animal is generally allowed to go wherever members of the public can go. So if a private business, for example, let's say they're offering private tours to the public and you can pay $10 to do a tour of the brewery, go behind the scenes, and well, that means the service animal can go there as well. If the public can go there, then generally service animals can go too. Can be excluded from certain areas if it fundamentally changes or interferes with the business, if it jeopardizes safety, if it goes against public health, or if it's out of the handler's control. So public health is a high standard. If it might endanger the public health, you might see this in a situation where there might be, like at a zoo, where there may be exhibits where it would be dangerous for a service animal to go into that area. That would be a legitimate reason to exclude. If you're having surgery and the doctor could clearly say, well, your service animal can't be in the operating room with you. Well, there really isn't a need because you're having surgery. Those are situations. Out of control, you have the definition of control. It's important to realize that control the person may have control of their animal with a leash or with verbal commands, or give the handler a little bit of time. If there's case law where settlement agreements where somebody was asked to leave a public space because the animal barked, and the business thought, well, the animal's out of control, it's barking. Well, that was how the animal was trained to tell the owner that something was happening. So it's important to understand the context. Out of control could mean different things. It's important to have a conversation, a dialogue with the person if you're asking them to leave. And then a word about that, if you're asking somebody with a service animal that you believe is out of control and you ask them to leave, the business and the Title II entity must still let the person come back in without the service animal. Because the issue was the service animal, the person still has the ability to come in and access that business without them if they have somebody there to take care of the animal outside of the business. Other common questions. Breeds. The ADA does not restrict the type of dog breeds that can be service animals. Some people have multiple service animals. It's possible. We get questions on the hotline. Does this really happen? It does. Some people could have multiple disabilities, and the service animal may be trained to do different tasks, different animals to do different tasks. It may not be possible to accommodate more than one. So it's important to have that conversation. If there's a reason to exclude one of them or more of them if they have more than one animal. Service animal training, the ADA does not cover service animals in training, but Oregon state law does. Some other support animals, these are not considered service animals under the ADA, emotional support animals, therapy animals, comfort, or companion animals. These are not under the ADA. However, service animals and related laws, Fair Housing Act does include emotional support animals. That would be a housing accommodation. But again, that's not the ADA. And the Air Carrier Access Act has the same definition for service animal, a dog. And airlines may choose whether to transport other species. That's up to the airline. But the Air Carrier Access Act covers flight. The ADA will cover you into the airport once you get on that plane. That's the Air Carrier Access Act. All right, thank you very much. Are there any questions?
Thank you, John. An informative presentation. Are there any questions? I see Christina going for her mic.
Yeah, this is Christina. I do have a question. One of the things that we've been hearing from folks is that for housing, right, there's so many units have to be accessible. But then if there's wait lists for those units and they don't get, a person with a disability does not get one of those units, how have other municipalities dealt with that? Is there anybody doing anything that helps the right people get into the correct units?
Not aware of best practices for that. That's a great question, and I'm sure there is. I'm happy to do some research to find an answer. The ADA doesn't require, or the ADA requires certain accessibility concerns for housing. And in a Title II sense for public housing, there could be some requirements that the Title II entity make sure that there's effective access and that they're addressing those issues. But accessibility within the housing and operations within the housing is a Fair Housing Act issue, which would be different.
Thank you, John. And Christina's question is well taken. We here in Salem, John, we're undergoing, it was just approved at the last council meeting, the housing production strategy here. Like places all over the Northwest, we are very behind in our housing opportunity, but we're setting aside X percentage of new housing to be accessible, but our experience here is that we're not filling it with folks who maybe need those accessible features and architecture and that built environment. And so we're kind of at this the growing kind of divide between what is on offer or what might be on offer and what is actually being taken up in use and in practice. And so we're trying to figure out how, part of the work of this task force is to figure out if there's any way we could form a recommendation that is coherent and practicable for the city.
Interesting. Yeah.
Dan, I see your hand is raised.
Yeah, thank you. I'm Dan. I'm a council member. I did want to bring up a little bit. I know we're talking a lot about businesses and so forth, but also when it comes to city and state requirements in general, I'm seeing things that are being built claiming ADA compliance. Yeah, I'm not able to really determine what ADA compliance actually means. Because if it's specifically targeting accessibility and also the difference of a general requirement like a wheelchair ramp or something of that sort versus a personal accommodation. And what's the distinguishing factor between the two? I'll lead a little bit more into that question with I've seen like parks that say they're ADA compliant, or here in town we have our local park with the carousel that is ADA compliant and has ramps. However, that particular park doesn't have any type of built structures for things like mental disabilities or psychological disabilities. Those are not things that are being required. And so a business can claim, or a location can claim to be ADA compliant and can claim to be accessible when they're really only being accessible to one particular audience. And I kind of know what you said about asking for those individual accommodations, but you have people who maybe have physical disabilities that are not required to ask for accommodations. When people that have mental disabilities, the built structures are not just automatic, and they're being required to ask for the accommodation. So just kind of, I had a lot of questions in there. I'm just kind of seeing what your take on that is, and what is ADA compliant and what does it actually mean?
Sure. Thank you for that question. That's a great question. It goes into really, there's two perspectives. There's the design guidelines, which are published by the U.S. Access Board. They publish many guidelines for ADA, what they would describe as compliance under the ADA for the built environment and for designs. So the design guidelines have there's very specific information about public parks, for example. So those guidelines are in place. There's flexibility, but those guidelines are really for aspects of that structure. Title II would deal with the accommodations to make sure, for modifications to ensure access. So the Title II entity, let's say it's the city, if the city is operating a program as public recreation, then they have expectations for how those services and programs will be operated. Somebody that with a disability that might need a modification to a specific policy under Title II, those requests the individual needs to make the request. And so the city itself should have a notice aspect, should have some kind of notice published. So Title II will make the distinction between providing a modification and then asking for information, or requiring the person to make the request based on how obvious it is. For example, if it's obvious that if I'm a wheelchair user and I need a modification, the Title II entity should know because they see me in the wheelchair. But if it's an invisible disability, they may not be able to tell. So by providing that notice that this is the mechanism to request a modification, the person with an invisible disability can see the notice and say, okay, well, I want to access this program, this service. I'm going to do the steps required to ask for the modification. So it's the Title II is programs, services, and a city making modifications to their policies so that everyone has meaningful access. And then ADA compliant for guidelines are the design guidelines that the U.S. Access Board has published on their website. And those deals with the specific structural, architectural issues around a space. So whether it's if it's a public park, there's all kinds of requirements. If there's a boardwalk, there's requirements. So those are things that are structural design guidelines, making use of that space, Title II, working with the city to make sure that there's effective communication and meaningful access. I hope
Okay, so what I'm kind of hearing is when you're using the term access, you're really talking about a physical access to a building or to a location. And is that the limit of what is being mandatory?
Well, there's mandatory for physical access to a space, and it's mandatory that you have access to programs and services. So that term is used in different ways depending on depending on the context. The programs and services are under Title II.
Okay, because the way I'm kind of seeing it as well is, okay, so we know X amount of our population may have a physical disability and need a ramp. And so that has been a requirement of our built structures for a very long time. But then we also are discovering that more and more people have more cognitive disabilities. And research shows that a large percentage of our population would benefit or have better access if some cognitive features were automatically implemented and not required to be asked for. And just as an example, I can just think of off the top of my head is if you know a location is going to have events over 5,000 people, should that location be required to have a sensory-friendly room built into the structure? And things like that is kind of where I'd like to see more exploration go into, so that people with a cognitive delay or a cognitive disability aren't being required to go beyond their disability and ask for assistance.
Thank you. That's a great point. And there, even under Title II, there's this concept of if you know, you know. So if you should know, or if you should reasonably know that this is something that you should do, then you could make the argument that the Title II entity should have been proactive before the person asks. So I think that touches on a little bit about the sensory room. If you know that a large proportion of the population is gonna need a space separate, then if you know, then that should be provided. But that starts to get into a legal issue as to, well, do we know? Do they really know? I don't want to go that far and down that path. But in general, ADA Title II, if an entity knows, if they reasonably should know that somebody needs assistance or will need so that they can have access to the programs and services, then they should make the modification to their policies generally.
Okay, and that's kind of like having the sensory rooms in the airport type of consideration.
You do see that in airports, and I think it's because they know that people do need that, and that's it's becoming ubiquitous. I think the Sunflower program and the sensory rooms, I know SeaTac has them. I don't know if Portland's airport is participant in that, but that is becoming more common.
Okay, so this was going to be a several-part question. Now, where I kind of noticed is there's a local park in my neighborhood that's currently being built as we speak. They do have several signs and notifications up claiming that they are building the park to ADA compliance. However, I'm not finding that, as you've said, ADA does not enforce anything, does not check anything. So besides an internal comment claiming ADA compliance, is there any oversight to what that means or who can claim ADA compliance?
Well, just to clarify, we don't do enforcement. So the Northwest ADA, but the ADA does have enforcement bodies. The Department of Justice would enforce ADA compliance if somebody was to file a complaint. Or in Oregon, Oregon has its own laws for non-discrimination, and there's certain standards that they have as well for public spaces. So there's different enforcement bodies that would look into that. So the ADA has built in that the Department of Justice would be the enforcement for Title II entities if there is an issue that needs to be investigated.
Okay, but until somebody brings up the issue, they can claim that they're compliant.
Yeah.
Okay.
Yeah.
No, yeah, that just seems, so anybody can claim that they're compliant until somebody brings up an issue.
Well, generally, no one's going to investigate the non-compliance.
Yeah.
And I don't, yeah, if I wouldn't want to, depends really, because there may be different phases of development, and it's until something is finished, you're not really sure if they've done everything they plan to do. So it's a lot of speculation. So I just don't want to get into speculation about what's happening.
Okay, that helps me get an understanding. Thank you so much.
You're very welcome. And if you have other questions, please give us a call, 800-949-4232 for general ADA questions.
So, John, I just want to, before we move on from Dan's kind of line of inquiry, do you have any examples of legislative changes by a Title II entity that have kind of gone above and beyond in terms of requiring the creation of inclusive spaces, be them sensory or otherwise? That we want to follow our recommendations after?
I'm happy to do some research, but I don't have offhand a list of some like best practices or things that have happened recently that would be helpful. But I'm happy to do some research.
I appreciate we're bombarding you with questions, and yeah, but it's generating a lot.
Sure.
Things like you did mention that I think it was Seattle defines a service animal. There's a lot more that they define as service animals, things like that.
Yeah.
Okay.
Where we could go further than what the floor is.
Any other questions? I have a few, but I'll wait for others to ask theirs if they're. Mr. Vice Chair, nothing?
I've got nothing.
Okay, I couldn't tell if you were waiting to jump in. Well, again, just thank you so much, John. And I also want to be respectful of your time. But I have a couple questions, and I appreciate that you may not be able to answer some of these if they kind of run afoul of the parameters of this conversation. But I was wondering if you could speak more to any case law that had a more robust definition or guideline for what amounts to undue financial burden for Title II entities. We've had a lot of input at the commission level and things we've been chewing on here at the task force level around, how do we negotiate that? Obviously, there is outstanding need in our community, and also we recognize that Salem, for example, has huge kind of budgetary problems and is living at kind of an austerity level, and we just had a life-saving investment by voters here, but we're still in very turbulent waters here locally. But in any kind of remedial steps, likely on the big questions, especially around infrastructure, would be unduly burdensome. I can imagine situations where even though something might be unduly burdensome, people's lives may be at stake, or I'm thinking it might be intersections or other things that are for which kind of poorly performing infrastructure may have significant kind of life consequences for residents here in Salem. So could you speak more as to what amounts to undue burden financially? Is there a threshold, in other words, or some case law that speaks to that more robustly?
Generally, if there was a DOJ enforcement action, it would look at the resources of the entire body. So it would probably look to the resources of the city. The expectation is that those resources could be pulled if necessary. That's very general. So I don't have like specific settlement agreements for that directly answers the question, but I'm happy to do some research to see if there is something on point that gives a definitive answer. The ADA does have some discussion about percentages. for example, if a Title III entity was going to make a modification, if they're upgrading a building, generally that 20% is a threshold number where they'll say, well, if the cost of improving the accessibility goes further than 20% of the entire budget, then you don't have to go further than that. But those are kind of some of the rare percentages that are offered within the ADA or in some of the DOJ guidance. So in general, a financial burden for a Title II entity is going to be very dependent on the resources of the city itself.
Thank you. I have two more questions, but I have one more follow-up, if you don't mind.
Mhm.
A lot of the ADA is framed in terms of what amounts to a civil right on behalf of an American who has a disability, and it kind of contours what businesses and physical accommodation and governments are to do or not to do. Are you aware of the inverse? So, for example, the threshold point for me was kind of it just occurred to me that, for example, I can imagine that it would be economically burdensome, for example, to expect, I'm making this up, but someone with disability to have to put in over a percentage of their monthly income or annual income into making their house accessible or something. Are there any legal protections? I guess it's maybe an economic justice question, but is the opposite true in anywhere that you're aware of, where folks are protected against undue financial burdens for themselves and individual disabilities as they navigate life and make their homes accessible?
Yeah, I'm not aware of any examples for that. It's an interesting question, and I'm curious if there are, but I'm not aware of any.
Okay, and thank you. And so my final two questions are, I think, quicker. One is, do you have any examples of really strong private-public relationships in different municipalities for helping Title III entities meet their ADA guidelines and expectations? Meaning, are there any cities, for example, that you can imagine that do a really good job of supporting their businesses and meeting ADA compliance?
Again, I'm not offhand, I don't have an answer for that, but I'm happy to do some research to see if there's something illustrative that would be helpful. I think some cities are a little bit better at working with the community that have created ADA coordinators for people to reach out to, or people that have that notice. Some cities are a little bit better at making sure that their websites have notice information or make it clear who that person is to reach out to. So there's varying degrees, but I don't have what I would say a definitive list of great partnerships that I would share at this point. And I'm not aware of any cities that have what's called an ADA enforcement officer, where there's somebody who would be a point of contact for the public that would help them in that enforcement aspect, or help them in any kind of investigative facility within the city. ADA coordinators often are dealing with contact within the body of the city itself to make sure that program services, those modifications are put into place. And they're dealing with the city itself and not necessarily with a business.
Well, I think you may have just found a new data point for you, John, because Gretchen Bennett, our staff person, fulfills that function here in Salem. She's not an enforcer in terms of enforcing kind of the weight of the city on behalf of residents, but she connects folks with resources for non-city related ADA compliance issues. Fair, Gretchen? Thumbs up. So yeah, so that's one example of that.
Bravo.
My last question, and then I'll stop my interrogation, John, and I apologize, is around effective communication. A couple years ago, the commission required Title III entities to have at least one TV to have closed captioning at any given time, and that's part of our work that we were doing here before my time, but that this body did. And it kind of raises for me questions around what constitutes effective communication. Namely, I think it mentioned being limited in your presentation, namely maybe ASL interpretation being required or some other mode of communication. But I'm thinking particularly around what responsibilities or resources does the city have, or obligations do we have to make sure that the information that we have accessible is actually reaching folks who need it, recognizing that there are a lot of folks with disability who maybe may never interact with city materials or content or staff or anything like that. And so, I mean, my question, again, maybe too vague, maybe not answerable tonight, but do you have any examples of a city that has done a good job of really getting out into the community and getting folks into the conversation that otherwise wouldn't be a part of that conversation, recognizing that oftentimes the very people that we want to serve through these laws are not getting the information and resources that they need?
I think it's going to vary, and oftentimes the reality is that it's departments within a city that are making different levels of effort to reach out to the community. There's generally a city may have on their website the notice requirements, the mechanism for people to reach out to request accommodation. The new Title II rule from the DOJ that was issued last year is going to require all Title II entities to have their digital content and their mobile apps to be updated. So all of that has to be, everything has to be updated so that people with disabilities can access digital content. So the larger cities, that deadline is looming next year. So my perception is that there's still a lot of sporadic levels of compliance with the digital content. And then there's still a lot of variation in cities providing the notice for how to reach out to request an accommodation or request a modification or request accessible materials. That's, to me, a continuing issue is the notice, and then having that information digitally available. Generally, those ASL interpreters, for example, are at many meetings because there's an expectation that somebody may, if there's a history of not having somebody requesting ASL interpreters, it's reasonable to provide some kind of request for notice so that, especially in the business context where not every business can afford to have, an ASL interpreter on staff in case somebody walks in. So it's anticipating the demand and having policies to reach out. Video remote interpreting, for example, is effective when somebody has an unexpected demand for an ASL interpreter. But in terms of which cities are doing this the best, my impression is there's a wide variety of compliance. And it's the individual departments that could be a little bit ahead of each other. And as they continue to work toward that digital accessibility rule that's pending for compliance next year.
Thank you. That aligns with my experience of city governance as well. Any other?
Let me just add, it's helpful. I've seen it's helpful when departments are proactive and when they're using social media to make it known to the community that they're aware of different communities with disabilities. Last year's Snohomish County Health Department, for example, did a huge project that I was part of that was how can we make health information accessible to people with different disabilities. So it's changing their content, changing their social media, just to give awareness so that people know that this entity is sensitive and aware and can be trusted to provide those, to meet those accessibility demands.
Awesome. Thank you so much.
You're welcome.
Thanks for John. Before we let him get back to his wonderful evening. All right. Well, John, thank you so much. I have to confer here with our staff person, but I'm not sure what's reasonable or not reasonable. A request of John and his colleagues around any presentations follow up, but know that will be forthcoming in some capacity. And so I just really do appreciate your time tonight and look forward to our continued conversation.
My pleasure. Thank you very much. Thank you for having me. And thank you for all the great questions. That was a great discussion.
Thank you. Take care. All righty, folks. We have some community engagement coming up this month and rolling into next. I think we have a review of that timeline that's been requested of us, as well as any day scheduling in September with the holiday. And I think Robert may have a preliminary presentation around that survey that we were talking about last time that we'll be handing folks and walking folks through during these outreach. So either one of you, however you want to conversation started.
Yes, thank you, Mr. Chair. Gretchen did a fantastic job of building out the questions and then sending them to me, making my job completely easier in translating them over. Unfortunately, due to technical difficulties, we can't really share what it looks like, but we can walk through the questions and then some of the language that's in the survey before we publish it, and then it'll be launched. In the convenience of having it digital is we can share it via social media. We can get a lot more responses through this survey beyond just the events that we have planned. So the Salem Human Rights Commission Disability Access and Inclusion Survey. The City of Salem Human Rights Commission wants to better understand the experience of community members with disabilities. We have formed a task force made up of people with lived experiences and professional expertise to help us identify barriers and advance equity in our city. Your voice matters. By sharing your experience and ideas, you can help us identify barriers that prevent people from fully participating in city life, shape recommendations for improving accessibility and inclusion and quality of life, inform the city's planning, policies, and projects. This survey should take about 10 to 15 minutes. Your responses will remain confidential and will be used to guide the task force work and recommendations to the city. Thank you for helping make Salem a city that works for everyone. The first section is an About You section. What age range best describes you? And then that is a drop-down select one with age ranges under 18, 18 to 24, 25 to 34, and so forth up to 65 plus. Do any of the following types of disability or conditions describe your experience? For the purpose of this question and survey, disability is based on your own understanding and experience. A formal diagnosis is not required. We recognize that some people identify as having a disability or experience barriers related to a condition, even without medical confirmation. This is a multiple select, and the options are visual impairment, deaf or hard of hearing, mobility disability, psychiatric disability, cognitive disability, intellectual or developmental disability, communication disability, autoimmune condition, sensory disability, dementia. I am a caregiver for someone with disability, or other, and they have the option to type something in. What best describes your current housing situation? I am unsheltered living, hold on, I am unsheltered living in a car, tent, or outdoors. I'm staying in an emergency shelter. I'm staying in transitional housing. I am temporarily staying with friends or family, couch surfing. I rent my own home or apartment with a housing subsidy, i.e. Section 8, or rental assistance through a nonprofit. I live in supportive housing with services provided on site. I own my own home. I live in a group home or residential treatment facility. Prefer not to answer, or other. Your experience in the city of Salem. In your own words, please share your story about living, working, or spending time in Salem as a person with disability. Have you experienced any barriers that make it harder to fully participate in the life of the city? In which parts of Salem do you most often experience these barriers? Downtown, North Salem, South Salem, East Salem, or other? In what types of places have you encountered the most?
West Salem, Robert, as well.
Gretchen. No, I'm kidding. We'll add West.
I'm just
Salem.
teasing you. Sorry to interrupt your flow.
No, let me add that real quick here before I forget. So we have downtown, North Salem, South Salem, East Salem, West Salem, or other. In what types of places have you encountered the most significant barriers? This is a multiple select. Parks and outdoor public spaces, sidewalks, streets, and crosswalks, public buildings and facilities, businesses or private buildings, public transportation, housing, or other. Do you have suggestions for how the city of Salem could remove these barriers? This is an intertext field. And then we have a follow-up section. Are you willing to be contacted for a follow-up conversation or focus group? Yes or no? And then would you like to receive email updates from the City of Salem Human Rights Commission, including news, events, and opportunities to get involved? If they select yes to either one of those, then it prompts a field for them to input their name, phone number, and email. I will take questions from my fellow task force members.
Before we go to other people, I just want to say thank you so much to Gretchen and Robert. July was not my month. And so I really do appreciate that they put a lot of work in. I thank you to both of you for doing that. So any questions?
Could you read the housing options again?
Yes, let me pull it up in a different view so I can actually read the whole questions as they're presented.
And before you do, Robert, I will say, I just, I didn't hear non-subsidized renters as a possible option.
That's why I asked.
Yeah, so it's, I'm unsheltered, e.g. living in a car, tent, or outdoors. I'm staying in an emergency shelter. I'm staying in transitional housing. I am temporarily staying with friends or family. I rent my own apartment with a housing subsidy, e.g. Section 8 nonprofit and rental assistance, HUD-VASH, etc. I rent my own home or apartment without rental subsidy.
Yeah,
I live in
that's it.
supportive housing with services connected to housing. I own my own home. I live in a group home or residential care facility. Prefer not to answer or other.
Perfect. Thank you. I didn't hear it if you said it before. I'm sorry.
Yeah,
And then for the where do you experience barriers? Did you mention multiple areas or citywide?
yes, so for where they experience barriers, it is a multiple select question, so they can select multiple options.
Understood. Okay, perfect. Thank you. Oh, I'm sorry, Dan, go ahead. I didn't see your hand.
Yeah, so I just I'm gonna be the thorn in the side again. So on the disabilities list, can we ensure that we have neurological conditions? That's not something that I saw on there, but that is the definitive medical term that autism falls under.
So would
How-
you, so, because
Neurodiverse.
I'm making edits as I go, so neurological disability, is that how we want
Or
to?
a neurological disorder or neurological condition.
Thank you,
They're
Dan.
both acceptable. And then also, I want to comment that almost all of these barriers seem very physical, and they're in reference to physical locations. But I would also point out that there are barriers to events or barriers to spaces. For example, there might be a barrier for someone engaging in a political environment rather than a physical environment. Or there's barriers to people engaging in community activities, not based on the physical location or place, but they are excluded from participating because of cognitive barriers.
So Dan, how is adding an option that says something to the effect of public event or community activity?
On the spot, I'd have to say I would need to pause and get back to you with something coherent.
Okay. Thank you. And Christina, I hear you. Go ahead.
Maybe something along the lines of, are there enough, maybe if you're, I don't know, if you're housebound or otherwise cannot attend an event or activity, are there enough options for you to engage, say, online or virtually? For example, if somebody had some sensory issues and they wanted to give public comment at a city council meeting, but there were 200 people there.
Yeah. You're
What-
exactly touching what I'm on. Or for one other example is Salem Library has a children's story time. I would love to bring my daughter to that story time as a 2-year-old. However, because of the mass amounts of people that are in that environment, in that small space, I cannot cognitively do that. So that is a barrier to me to being able to bring my daughter into public spaces.
Right.
So how would
So
But-
I'd have to brainstorm a little bit to know exactly how to word that, but I can get back to you on some suggestions.
I feel like some of those are probably answered or they have the ability to be answered in the question, in your own words, please share your story about living, working, or spending time in Salem as a person with disability. And it could potentially be entered as a text field to, have you experienced any barriers that make it harder to fully participate in the life of the city? Someone could say attending.
Oh, I'm sorry. I agree that it can be there. However, the context of the overall survey is heavily pointing towards physical. So I would assume that those questions are asking for physical barriers.
Maybe you can specify physical or psychological barriers. Or I'm trying to think of another word, physical or unseeable barriers, invisible barrier. I don't know.
You might be able to phrase
Yeah.
it as any and all barriers.
Yeah, any and all barriers is nice. I don't-
Yeah, I think just making it more broad helps.
Well, if ecological, we start omitting other barriers.
Yeah,
But I mean, community,
Correct, yeah.
any at all. Any at all is a point that's well taken, Haley. Thank you. I would like to see, Robert, to Dan's point, though, having a public event or a community activity be incorporated in the list of things, and that can mean a lot of things to a lot of people, and there'll be other opportunities for them to elaborate or detail that. Other types of conditions that I often see in other lists but didn't see this time was having a separate item for a short-term or temporary disability. And then similarly, having an item for a chronic health condition. Some folks in the community don't experience barriers, and that's a part of their existence and their identity, but they wouldn't maybe identify as disabled, but have a chronic health condition. So just want to note that. Tony, my goodness, I apologize. I didn't see your hand. Go ahead.
Well, first of all, I wanted to say that under the list on the survey of the various disabilities, is that, are you able to make multiple choices, or are you only allowed to choose one? Because even Helen Keller would have to mark 2.
Yes, good question. This is a multiple select, so they can select all that apply.
On their disabilities?
Yes.
Okay, and then on the other issue, what might be helpful is just to add the question, has there been an event, within the city that you were unable to attend, and can you tell us what kept you from it?
I like that question.
Yeah, an event, function, activity, something. Yeah, I like that.
Yeah, we can format it to where they can select yes or no, and then it'll prompt them to type their experience in.
If they select yes.
Yes. And were there any events that you felt excluded from based off of your disability? Is that what we want to ask?
Yeah, I like that.
I think more positively, like you couldn't participate in because of or as a result of your disability. Is that fair, Tony?
Yeah. I mean, I agree. I think the less specific we are, the more unexpected data we might receive that would help guide us where we need to go.
Any other feedback or comments on the content of the survey? As a reminder, I think the first time this will be seen by people is Monday. So, Haley, go ahead.
Sorry. I know that there are people who have short stature who are not considered disabled because it doesn't, to a lot of people's definition, doesn't just count as a disability, but it does affect reaching and a bunch of other access things. So just adding short stature to that just comes from being in the Paris field where they specify it as short stature for instead of a physical disability, unless you have other underlying physical disabilities.
I like that, Haley. If I can ask a clarifying question,
Mhm.
do you think you can have that be more encompassing by saying something to the effect of short stature, body type, or body shape? To have it be specific, but also inclusive of other.
Short stature is kind of the universal term, just because there's people like to ask me, well, what about little person or dwarfism as it? And there's people who are of short stature, but they don't have dwarfism. So short stature kind of encompasses.
Yeah, thank you. I meant
Yeah.
apart from short stature. There
Oh
are
yeah,
other body type or body shape disabilities I can think of that might.
I think that would work.
Our list now includes, because I've made those edits, I'll just read through this list of types or conditions that people can list. Visual impairment, deaf or hard of hearing, mobility disability, psychiatric disability, cognitive disability, intellectual or developmental disability, communication disability, autoimmune condition, sensory disability, chronic health condition, dementia, neurological disorder/condition, short stature, physical/body type. I am a caregiver for someone with a disability. And then the other field still applies. And then we added a question: have there been any events or activities in Salem that you felt you couldn't participate in due to accessibility barriers or disability-related reasons? And then for the barriers question, we can add a note that says barriers may be physical, sensory, communication-related, social, digital, attitudinal, or systemic. Thank you, ChatGPT.
Thank you. I just want to note that we are at time, so a little bit over, in fact. So if you do need to go, I will not be offended. And thank you very much for your time. But we're going to wrap up the conversation if possible. Tony, I see your hand, and then I also need to get to Gretchen around any scheduling for this month and next. So briefly, Tony, if you can.
Yeah, I just thought maybe on the list of disabilities, we add the open-ended, or something we haven't mentioned, please enter here.
Yes, that's captured under the other, and then they can type in their response.
Great.
Oh, okay. Sorry, I'm not an auditory learner, so it's hard for me when I can't look at something.
Yeah, no, I 100% agree. And ideally, we would have been able to pull this up, but we're still working out the tech kinks. And I imagine Gretchen and I will have that down by the end of this next quarter. So
I'll turn it over to you, Gretchen, for scheduling.
I see Dan's hand up. Do you want?
Oh, go ahead, Dan.
So I just had a kind of a final question on the survey is, how is that going out? Who's it being distributed to?
So the different ways, Dan. So we have these in-person events, one of which I think you're helping co-host.
Yeah.
We'll be taking these surveys. That'll be available in print as well as digitally to participants. And I imagine there will also be maybe a city listserv version of this as well. That'll be going out to folks who subscribe to city content. So both in person and online engagement.
Joaquin, thank you. To get to the scheduling item, I wanted to just point out that we're not able to meet on the first Monday in September. And I'm happy to poll you via email, given that we're out of time tonight. But I wanted to suggest kind of two odd suggestions for dates. I wondered about August 18th for our next meeting or September 15th. when I looked at the city calendar, it's crowded right around the date. And so I wanted to suggest something sooner or later. If there's not an immediate love for one of those dates, though, I can send out a scheduling poll.
We have another meeting that day on the 15th for the task force
We do,
as well.
okay.
Just so that's a lot of each other. If you're tired of me by 3 o'clock on the 15th, I don't blame you.
And I am out of country on the 15th for a family reunion.
And Haley's doing more important things and more fun things.
Any reaction to just meeting again in 2 weeks? That would be after 2 of our engagement opportunities and give us a chance to debrief those. Otherwise, I can send out a poll.
I like that. 18th is I like the idea of coming together after having the first wave of engagement, knowing that there'll be other waves of engagement subsequently. Can folks do the 18th at this time? I see yes from Haley and Tony.
I go where I'm told.
Yes, I can.
Dan says yes. Robert says yes. It's a Monday.
Yeah, my Mondays are.
Well, gosh, we just saved ourselves a poll.
Oh,
All right. Anything else, Gretchen, apropos of scheduling?
No, sir. In terms of Monday, I'll connect with a couple of you to confirm like who's kicking off the conversation. We have good notes from last meeting about how to structure the day.
Okay.
So I'll follow up on that.
I'm sure we'll be touching base over the phone as well, Gretchen.
I just want to ask, I did send Robert an email, but it probably went to his spam folder. Is the community room at Sequoia Crossings reserved? Because I had a note that you were going to do that.
Yeah, when I spoke to the program manager there, sent that person a text and she said it was that she would get it there and I can follow up. What day what day are we going there?
Next Monday.
Next Monday, the 11th at 3 o'clock.
Okay, I'll follow up, but it should be we should be reserved.
And I'll add, Tony, I'm sure happy to stand outside in the courtyard if there's people excluded from the community room that want to talk to us. I could be someone, and maybe there'll be others too, that are happy to connect with people outside that room too.
Yeah, so the message that I sent was, is it possible to have a listening session at Sequoia on Monday, August 11th at 3 p.m.? And then she said, yes, reserved. So I'll just double tap that, but we should be good to go.
Sounds definitive to me.
Okay.
Not, it should be sunny and warm and we can do it outside in the courtyard. So we'll be there.
All right. I just really want to, before I ask for any final remarks or comments, just want to thank you all for kind of a sprint of a meeting, but I hope a productive one. And I just appreciate all of your engagement and continued thoughtfulness in this process. So with that, are there any member remarks or announcements tonight? All right. Well, hearing none, I'm going to strike this gavel.